that are there. An IP-friendly adjudication regime would encourage local businesses and also recognize foreign IP owners. That is not to say that the IP field is an elitist or a sophisticated field meant for the rich people. That conception is completely misplaced. More than 80% of the trademarks which are filed belong to domestic businesses, and till 5 years ago, only 20% of the patents which were filed were domestic. However, recent trends show, as of last year, 40% of the patents filed in India relate to domestic inventors and domestic inventions. Thus, India ought to aspire to increase the percentage of patent filings, increase innovation, and this shows that these filings show that India is moving in the right direction. This is the time to recalibrate IP adjudication across the country. Apart from providing efficient systems for those litigants who knock the door of our courts, the base of IP litigants who seek protection, enforcement should be increased. Individuals and small inventors ought to be provided a system which welcomes them. The costs of adjudication ought not to be prohibited. The manner in which this can be achieved is by creating an IP adjudication system which is uniform across the country, beginning with the commercial courts at the district level up till the IP divisions in the high courts. Accessibility ought to be improved without compromising on the quality of adjudication. This can be achieved through interlinking IP courts and the commercial courts with the IP division in various high courts and sharing of best practices and knowledge. In fact, this seminar is one step towards that direction. The interlinking of these high courts, IP divisions and the commercial courts would lead to quick adjudication which is transparent and of high quality. Assistance required for the commercial courts and the IP divisions should be readily available through this network in the form of procedural assistance, access to experts from various areas of law, economics, science, and the continuous engagement on such a platform. India's legal position, both statutorily and by judge-made law, including sections such as 3D, received some reluctance in the initial years. However, as the pandemic would show, India's position has been affirmed as one which is having the right word for intellectual property, and that is balance. While recognizing the rights of IP owners, the larger purpose of IP has not been forgotten by India, and that is for the betterment of society. The role of IP and persons who practice in this area is very crucial to ensure this balance. The IP jurisprudence in India is extremely rich and thought-provoking. In respect of IP's India's IP jurisprudence, the need of the hour is to disseminate this jurisprudence globally, which is not yet happening, and therefore creation of these divisions and a large network between high courts should help the dissemination of IP jurisprudence. The creation of the IP division will hopefully enable this dissemination, and it would result in data analysis and generation of annual reports which would showcase India's achievements. As informed by our Chief Justice just now, more than 11,000 cases have been filed in the Delhi High Court since 2000. 90% of these cases have been disposed of. Now, with the matters being received from the IPB, the pendency of the IPR cases in the Delhi High Court would be 4,000 to 5,000 cases. This actually confirms the reason for the creation of the Intellectual Property Division. India's tryst with intellectual property has moved from the scriptural ethos of sharing to a country which introduced IP with reluctance when the chips happened. And now the story of the 1990s is over. In the 21st century, India is an IP-friendly country with its proud innovation and wishes to build on its strength. For it to move forward in this direction, the IP adjudication has to keep pace. In order for the growth in innovation to be holistic and all-pervading, the court system has to become innovation-friendly to both Indian and foreign IP owners. The Intellectual Property Division is just one defining step towards the same, and I would just like to end by saying there are miles to go before we see. Thank you so much, and thank you for the patient hearing.
Thank you, Madam, for presenting the background and the vision of IPT. I now invite our guest of honor, Mrs. Nirmala Sitharaman, Union Minister of Finance and Corporate Affairs, to address the august gathering.
Morning and Namaskar. Honorable Chief Justice of India, Sri Ramana Garu. Honorable Chief Justice of Delhi High Court, D.N. Patel Sir. Justice Pratibha Singh, Justice Sanjeev Narula ji. Judges of the Supreme Court, Chief Justice of several High Courts, judges and other invitees for this very important day. I'm honored to be a part of this program today, which is a national seminar. We are talking on the adjudication of IPR disputes in India. It was rightly recalled by the Chief Justice of Delhi High Court that this exercise had started sometime when I was in the Commerce Ministry. I'm indeed grateful for the judiciary to remember that little bit of a role that I played in the commerce. Those were very challenging days in terms of bringing out a policy on IPR, getting the stakeholders to discuss with the government for making the policy, and also understanding how we can strengthen the IPR ecosystem. India is at a stage where growth and the focus on development has got to be strengthened from every side. IPR plays a very important role in it. In fact, when the government announced the policy on startups and came out with steps to encourage startups, the spirit behind that was we should also give the startups the advantage by providing such policy framework, supports through schemes, so that the innovative thought of a startup, otherwise a startup is no different from any business which really starts up, but that idea of bringing in innovation into the thought with which they would like to build a business or module had to be given all kinds of support. So the whole push from the government was to encourage startups, have a formal registration mechanism, also understand their requirement for protecting their IPR. And also the IP protection together with giving them the opportunity to be able to commercially scale them up and build on it. Today, if I can quickly jump over 5 to 6 years, today we are seeing a number of these startups qualifying to become unicorns as well. This couldn't have been possible just with the government giving up a lot of restrictions which were there earlier, which were probably becoming burdensome. So simultaneously, as we were removing a lot of restrictive uh, rules and regulations, we were also making sure that with various schemes that we were able to support these uh, innovations and also give a framework with which they can work. Now, not just for startups, but also from the point of view supporting R&D itself in this country. R&D in this country has had steady flow of money coming from the government as a support, but to give a leap forward, it required for the government to be able to apportion that kind of money for R&D, whether it was specifically for space, whether it was for atomic energy, or for looking at very many genome related activities, pharma related activities, and simultaneously recognizing that India had a great advantage in bulk drugs manufacture. So there were so many different ways in which the idea of supporting patents, supporting copyrights, were all got to be encouraged and government duly recognized it. But as was mentioned by Justice Pratibha Singh, the question of wanting to give enough support for rights protection through law was the matter on which there were a lot of discussions happening. I was pleasantly surprised for Justice Pratibha to recognize the travails of the IPAE, and as that was one of the things which was concerning most of these new startups, we also wanted to engage with the judiciary, and to some extent, the engagement happened over several years, resulting, of course, end of the day, last year, when we really removed the tribunals and passed on the entire load of cases which were piling up to the courts themselves. But with a word of appreciation, I want to recognize the role of Delhi High Court for having looked at that load which was piling on to them as not a challenge, but take it as an opportunity that today we are here recognizing the fact that a division has been created, and that is just not created and left there. Consistent efforts by framing or having a committee look into getting a framework and also setting up the rules have all been quickly followed up, that today we are in a position to say a systematic approach to deal with the IPRs is happening, and that is where this quoting of the statistics saying numbers have increased is said with a sense of, yes, we can manage that, rather than saying numbers are increasing, how are we going to cope with it? So I appreciate the effort which has gone in making the framework, in setting the rules, and with a tone of assurance, uh, giving the picture that India's jurisprudence is very well evolved, that today, even handling a complex and global matter such as the IPR is happening with certain sense of confidence and strength. And indeed, I would like to have a word of appreciation and also respect for the Chief Justice of India for having been very supportive of this entire effort, and that gives a strength for judiciary all over the country to be able to see that there is a well established, well thought through process through which issues of IPR will be handled from now. Just to give you the numbers, which are very interesting, which partly got gathered when the two judges spoke before me. In 2013-14, there were 4,000 patents which were filed and granted, whereas now, in the last year, that has increased to 28,000. So this cannot happen unless there is a confidence in those patent seekers to know that they apply, they get it in due time, and if there are any complexities, the judiciary is there to dispense justice. So that is the confidence which has rapidly increased the number in the patents application and granting. Similarly, in trademarks, the number was 70,000 applications and granted patents, trademarks in 2013-14, whereas that has increased to 2.5 lakhs in the last year. Similarly, in 13-14 copyrights, there were only 4,000 copyrights granted, whereas that number in the last year has crossed 16,000. So these are not small numbers, and I'm very glad for these numbers, because this is where the strength of the economy in supporting such innovations and copyrights, all of which, when scaled up, are going to have a very strong ripple effect into the economy itself, and that would generate its own ecosystem and also revenues. So I think the boost which is given through the support of judiciary has actually encouraged more innovations, more patents, and more copyrights coming into India. And all the more impressive that I hear from Justice Pratibha, who's already gone into the statistics, done a deep dive, to say that a significant number of them are very Indian themselves. So that is a very strong message which comes through as a result of concerted attempt to give strength for IPR. A few steps which the government has, again, following from 2014-15, has taken up is to recognize several of these services which are so infused with innovation. such as the drone technology being now expanded into agriculture, expanded into services, and recognizing the service providers of drones as, like the way we say SaaS, service as a service itself, the software services. Similarly, in drones, we've come up with drones as a service itself now, as a result of which you're not just creating jobs, but are able to accommodate from a commercial sense the technologies and the innovations which are happening in the drone area. Similarly, for R&D in defense, we have said that industries and startups and academia, with 25% of all the defense R&D budget will be going over to them now. So there's going to be a lot of activity in that as well. So if these are gradually, because of the support and also in a way the captive nature of things which are being procured by the government, these are going to be very strong encouragements for greater activities, generating greater IP applications, I would think. And that itself is going to be, therefore, necessarily having an impact on the judiciary. Battery or energy as a service is also coming through, which again has a lot of innovation component in them. I've already spoken about the genome and also the geospatial areas. Semiconductors are also getting a big boost through the budget. Artificial intelligence, this is the world of Web 3.0, Industrial Revolution 4.0. So these are all driven with technologies and also through innovations. So as a result, the economic activity itself is moving more towards these areas, which are so dependent on getting their patent registered, copyright registered, and answering questions related to that. Rightly, these are not going to brook any borders. These are things which are going to be across international borders, and there is just not going to be any resistance from countries and technologies so long as they comply with the law of the land. And that is where I think judiciary has a big role to play. And now that the bench is been division has been created, the bench has been set up, you're going to be able to face the challenge of increasing numbers reaching the courts. But with this kind of a support, knowledge being shared, rules being set, framework being provided, I think it will be far easier for the courts to take up this challenge. One other scheme which I'll draw the attention of this August audience is that we in the government in 2016 came up with a pilot scheme for intellectual property protection, SIPP, wherein the cost of the facilitators or the payments that they had to make for challenges in the courts were all borne by the government through the Office of the Controller General of Patents, Designs and Trademark. That scheme has now been extended to 2023. It was brought in 2016 as a pilot scheme through which the payments or the charges being made by the facilitators, the patent agents and so on will be borne by the government through the Office of the Controller General. That scheme, after having been launched as a pilot scheme, has now graduated year on year moving forward, but now we have extended it to 2023, and I guess that's going to be one of the most important ways in which we can support technology and innovation. But that support is only for ensuring that people don't hesitate from the cost point of view. Because if it is going to be prohibitive cost, people are going to hesitate. But we need all the innovations. We need all the patents. We need the creative thought, because economy stands to benefit in a multiplier kind of a scale. If you look at it, it's far more than the general routine activities, which can, if you put it in a scale of 1 to 10, the general manufacturing, general production activities, if they gave you a level of 3 in a scale, innovative activities bring in about 7 to 8 is the informal understanding of the importance of these innovative ideas, patented ideas can bring to the economy, which is so required. Without taking more time, I'm immensely grateful for the support that the Delhi High Court and particularly Chief Justice Patel Saab has brought in. Chief Justice of Supreme Court, I'm grateful that he's been here physically to support this whole step taken by the Delhi High Court, and the two judges, Justice Pratibha and Justice Narula, for having spent arduous time in getting the framework ready, the rules ready, and as a result, I would think the country will benefit from this great exercise. I wish today's proceedings all the very best, and thank you for having me here. Thank you.
Thank you, Madam, for sharing your valuable thoughts with us. I now invite our Chief Guest, Honorable Mr. Justice N.V. Ramana, Chief Justice of India, to kindly address the gathering.
Srimati Nirmala Sitharaman, Honorable Union Minister for Finance and Corporate Affairs, brother and sister judges of the Supreme Court, Brother Justice D.N. Patel, Chief Justice of Delhi High Court, Chief Justice of various High Courts, Sister Justice Pratibha Singh, Justice Sanjay Narula, brother and sister judges of various High Courts, Mr. Mendrata, Secretary Law, Barun Mitra, Secretary Justice, Judicial Officers of Delhi, Registrars of the Supreme Court, law officers, senior advocates, members of the bar, other distinguished guests, media persons, and ladies and gentlemen. Very good morning, all of you. Except me, all the four dignitaries on the dais are very well qualified on the subject and their authorities on the subject. I am a lay person on this topic. However, I will try to do some justice. I am happy that 18 Chief Justices across the country and 54 senior judges, number 2 and 3 judges are here to attend this conference. It shows the importance of the topic. I am relatively a newcomer into this field of intellectual property rights. Even though I am a science graduate, those days we never thought of, we are never aware of what is this intellectual property rights. It is a alien to me and my generation. My understanding about the subject is very limited because as a judge only I dealt few cases. And once again in 2016 I got an opportunity along with Justice P.S. Thakur, the then Chief Justice, myself and Justice Kishan Dave, Pratibha Singh and Attorney General at that time, Mr. Rothke, we all toured almost 6 days South Korea and Japan, particularly on these issues to explain the entrepreneurs of Japan and Korea, how safe the Indian judiciary is, how independent the Indian judiciary is. Because any person who wants to invest in this country, they are scared of dependency, time taking, and independence of the system. However, we try to dispel their apprehensions, and we have prepared almost it's a 1 hour session, 15 minutes a slideshow, and 5 minutes explaining by me about the Indian judiciary, how the hierarchy and other issues. Pratibha Singh and Rothke used to explain the legal position and the decided cases and to create confidence in those people who want to invest. I can say this is a successful tour. Again now today I am forced once again to roll into the IPR subject. Intellectual property is a field of law which protects creativity and innovation. Its importance is also felt during the ongoing pandemic. Innovation, and that too quick innovation, has become the order of the day. With the onset of the pandemic, vaccines and medication had to be researched, trials had to be conducted, and commercial scale of manufacturing had to take place within a span of 2 months. When the future generations will look back, the past 2 years of pandemic will tell the story of human resilience and power of innovation. IPR touches every aspect of our life, from the food we eat, to the books and movies we enjoy, to the appliances and tools we use. IPR is not a new chapter in Indian jurisprudence. The earlier Patent Act of 1970 was framed with an objective to provide a reasonable balance between adequate and effective protection of patents on one hand, and the technological development and public interest and specific needs of the country on the other. With the advent of economic liberalization, the country's IPR regime has undergone a rapid transformation. This transformation has been driven by the compulsions of integrating our economy with the rest of the world. During the Uruguay round of the trade negotiation under GATT, the developed world pushed for mandatory inclusion of IPR in every sphere. Considering the fact that 99% of the global patents were held by the developed world, any agreement for their protection was perceived as favorable to them at the cost of developing countries. The inclusion of intellectual property in the agenda of trade negotiation was a bone of contention between the developed and developing countries. For some, TRIPS was a product of bargain, while others view it as a coercion. Generally speaking, the popular narrative in the third world was that IPR was a self-serving tool of the developed world to further their revenues from emerging foreign markets. As India was embarking on liberalization, it hoped that the international trade negotiation would help developing countries to integrate with the global economy on favorable terms. In the absence of level playing field, India and other developing countries had to negotiate over several rounds, aided by domestic pressure exerted by the opposition and the civil society. We had to bargain hard before achieving certain concessions while signing TRIPS. Today, India's position as the pharma hub of the globe is largely attributable to the existing IPR regime. Several pharmaceutical multinational companies have been contracting research and development to national laboratories in India for the last 2 decades. The existing framework has enabled a massive growth of pharmaceutical exports by India, with local firms building capabilities in making generic products. The lower price of generic drugs has enabled access to life-saving medicines for those in the developing and underdeveloped countries. Indian pharma has been producing low-cost treatment for HIV, tuberculosis, and malaria, and are the major vaccine producers of the world. Today, India has rightfully earned the title of pharmacy of the world. Whenever we talk about the IPR regime in India, it always reminds us of Novartis of India case. The Supreme Court stopped the practice of pharma industry to extend the patent period by simply tweaking some constant element. This decision has helped common man by ensuring that life-saving drugs are available at an affordable cost. The second sector I would want to concentrate on is the impact of IPR on agriculture. As a son of a farmer, my views can be taken to be biased. I understand the hard work and labor involved in farming. Agriculture is the backbone of our country. Our history in agriculture encompasses our ethos, culture, and living. In India, the art of developing new varieties and techniques usually gets passed on from generation to generation. Unlike Western countries, agriculture is seen as a community right. In modern times, private companies have entered this arena in developing new varieties and high-yielding plants. Huge investments in biotechnology have resulted in slow degradation of community knowledge, and it is replaced by private ownership. These companies expect a certain level of protection for the variants of plants they develop. In order to strike a balance between innovation and concerns of such rights of farmers and food security in line with TRIPS, India enacted the Protection of Plant Varieties and Farmers' Right Act 2001. The third area which I would like to highlight is geographical indications. From Banarasi to Pochampalli saris, from Darjeeling to Bangalapalli mangoes, Tirupati laddu to Dharwad peda. Geographical indications represents our tradition, heritage and territory. India has approximately 400 registered geographical indications. However, we can observe that there is a great disparity between the states in India concerning GI registrations. Though certain states are performing well, others are yet to catch up. There is an immediate need to take corrective steps to achieve the full potential of geographical indicators. Provisions for stronger enforcement and actions against infringements are the need of the hour. Awareness campaigns, especially in rural areas, are required to be undertaken. There have been a few success stories like Darjeeling tea and Chanderi silk. The success stories need to be studied and replicated in other GI as well. With the startups coming up in the big way across the country, driven by innovative youth, this field of law has become more relevant than ever before. Coming to the judicial setup to deal with issues related to IPR, a brief background of development in law should be looked into. It is historically known fact that prior to 1999 Trademarks Act, all litigation relating to intellectual property was being handled by the district courts and 5 high courts, namely Delhi, Bombay, Calcutta, Madras and Gujarat. However, in 1999, the Intellectual Property Appellate Tribunal Board, IPAB, was created as a specialized tribunal for dealing with IPR cases. When I visited Japan in 2016 to attend a conference IPR, I was repeatedly asked by the entrepreneurs as how investors friendly the Indian judicial system is. In fact, whenever I travel abroad, from cross-section of posts, I keep getting similar queries. My answer has always remained the same, that the Indian judiciary is absolutely independent. It always treats all the parties equally and equitably. The vesting of IPR jurisdiction back in the High Court comes at the time when the judiciary is already overburdened with the backlog. However, this would not deter us from raising to the occasion and putting in place systems which may be required to deal with the new regime. It is an appropriate moment to build sufficient capacities in our high courts so that intellectual property litigation can be conducted efficiently and smoothly. It is in this context that the seminar organized today is of significant value. The new and additional challenges can be effectively met by strengthening the High Court. Not only do we need to fill up the existing vacancies on urgent basis, but there is also a need to increase the number of judges. With better service conditions, we may be able to attract more and more talent in our court. Judicial infrastructure needs to be improved. Unfortunately, we are not even meeting the basic minimum standards in this area. It has been my endeavor since assuming the office of the Chief Justice of India to put in place an institutional mechanism to coordinate and oversee the improvement of judicial infrastructure. Mere allocation of funds is not enough. The challenge is to put the available resources to optimum use. I have been pursuing the government for setting up the statutory authorities both at the center and the states. I am waiting for a positive reply. It may be recalled that I have recently emphasized about the need of continuous training and upgradation of skills as one of the major challenges before the Indian judiciary. With the advancement of technology, we are witnessing more complex issues in litigation, be it IPR, IT, and other fields. The complexities involved demand assistance from experts and specialists in the adjudication process. The Intellectual Property Division of the Delhi High Court and its functioning would help hopefully serve as a model which could be replicated. We have in our midst Srimati Nirmala Sitharaman, one of the most powerful ministers, by virtue of holding the pulse strings of the country. Her area of research during student days was trade relations with the GATT framework. Her academic research, coupled with practical experience in the Ministries of Commerce and Finance, are a great help in formulating the policies. I am sincerely thanking her for showing the keen interest in these areas. I congratulate the Chief Justice of Delhi and all his companion judges setting up the Intellectual Property Division in Delhi High Court. It is happy and particularly noteworthy the efforts made by Sister Pratibha Singh, who is an authority on IPR. The fact that she left her lucrative practice is a testament to her commitment to public service. Another hard-working judge and very much compassionate and hard-working in the field of intellectual property right, Justice Sanjay Narula, made stellar contributions in framing new rules. My advice to the stakeholders is that while protecting the interest of today, we must not lose sight of the bigger picture. This is where a judicial mind comes into play. While adjudicating the claims of intellectual property rights, you must balance the contemporary claims with the sustainable interests of the future generations. With this, I wish you all success in this endeavor. I am happy to be participate in this seminar. Thank you once again for giving me this opportunity.
Thank you, sir, for your words of wisdom. I'm sure they will serve as guiding light for us. I now request Honorable Mr. Justice Sanjeev Narula, member of IPT Committee, to deliver the vote of thanks.
Honorable the Chief Justice of India, Justice V. Ramana, Honorable Union Minister of Finance and Corporate Affairs, Srimati Nirmala Sitharaman, Honorable Chief Justice of High Court of Delhi, Justice G. Patel, my learned colleague and chairperson of the IPT Committee, Justice Pratibha Singh, Honorable Judges of the Supreme Court, Chief Justices of the High Courts and other judges, my esteemed colleagues and the learned members of the bar. I consider it a great privilege to propose today's vote of thanks. On behalf of High Court of Delhi, I express my sincere gratitude to all the distinguished guests for making time to attend the event. Your support and enthusiasm has made this event a resounding success. I join my colleagues in thanking the Honorable the Chief Justice of India in setting the tone of the conference. Sir, you are very modest, but we all know about your vast knowledge on these subjects, including IPR. You have highlighted the public interest and the importance of creating awareness, which I think is the dominant factor that has to be kept in mind for development of law, and that indeed is the bigger picture that you have talked about. Your valuable thoughts expressed on this occasion will serve the field of intellectual property rights and the newly constituted Intellectual Property Division in good stead. Thank you for your presence, your advice and constant encouragement. On behalf of the High Court of Delhi, my brother and sister judges, I convey our gratitude and heartfelt thanks to today's guest of honor, Honorable Minister of Finance and Corporate Affairs, Srimati Nirmala Sitharaman, for accepting our invitation and gracing us with her presence. Madam, your insightful speech has truly set the benchmark for a series of resourceful and illuminating discourses on IP dispute resolution, which will indeed develop the IP ecosystem that you have discussed. The role of the judiciary in strengthening and supporting startup innovations and R&D is indeed vital, and we take note of that. I also extend my thanks to the Honorable Chief Justice of High Court of Delhi, Shri Justice D. N. Patel, whose presence marks his deep-seated commitment towards innovation and streamlining IP adjudication, recognizing that Delhi is the hub of IPR matters. Without your clarity, vision, and progressive ideas, creation of the IPD would not have been possible. In a short span of time, you have led this court into making important strides towards formulating an effective framework for adjudication of IPR disputes, which I am confident would further contribute towards IP jurisprudence. I would also like to take this moment to thank the chairperson of IPD committee and my esteemed and dear colleague, Justice Pratibha Hussain, to whom we all are deeply indebted for her painstaking efforts in establishing the IPD and for ensuring that its bones are ironclad. You have laid a strong foundation for cultivating specialization for resolution of intellectual property disputes. I'm delighted to know that this coming Monday, she will preside as one of the first judges in the exclusive IP division of the Delhi High Court in the format that we both had envisioned. This is indeed a defining moment, and I wish her the very best and look forward to seeing the rules being applied in practice. I also take this opportunity to thank all the members of the bar and the stakeholders who played a pivotal role in drafting of the IPD rules. Without your proactive contribution and valuable insights, the rules would not have been fructified in the present form. On behalf of the Delhi High Court, a very special thanks to all the distinguished Chief Justices, the judges of the Supreme Court, Justices of the High Court, and all the dignitaries in the audience who have made time from their busy schedules to be with us this afternoon. I would also like to acknowledge the contribution of the administrative staff of the Delhi High Court, the registrars, law researchers, secretaries, and other members for the relentless effort and support for making this possible. On behalf of the Delhi High Court, I extend my heartiest congratulations to the entire legal fraternity and especially the IP community. The full-fledged IPD assures dedicated judicial resources and time, and with time, this will generate numerous opportunities for all of you and encourage innovation and creativity. With your continued support, the Intellectual Property Division shall revolutionize and bring efficiency and consistency in the IP redressal system in our country. Thank you.
Thank you, sir, for the Thanksgiving. I request all to please join us for high tea. We will reassemble here at 12 p.m. for the panel discussion. Thank you.
यहाँ भी बगल में भी है।
Hello, 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 check. Hello.
Hello. Hello. I would request all the invitees to kindly take their seats. The session is about to commence. Kindly please take your seats.
Hello.
All the panelists, please, I would request them to kindly come on the dais.
Hello.
I welcome all once again. We now start with the panel discussion on adjudication of IPR disputes. For this, I request the moderator of the event, Honorable Mrs. Justice Pratibha M. Singh, along with the panelists, Honorable Justice Sonia G Gokani, Judge Gujarat High Court, Honorable Justice Soman Sen, Judge Calcutta High Court, Honorable Justice Gotham S. Patel, Judge Bombay High Court, Honorable Justice M. Sundar, Judge Madras High Court, Honorable Justice Sanjeev Narula, Judge Delhi High Court, to kindly join us on dais.
Justice Narula. Can I request the attendees who are sitting in the balcony to come downstairs?
Hello. Check.
Can I request everyone standing in this ways to come down? Please take your seats. Okay, a very good afternoon to all of you. We now come to the technical session and the panel discussion in this seminar. And I must say this is a historic moment for all of us, because never before have all the 5 high courts who have the intellectual property jurisdiction come together for a panel discussion. I'll start from this end by welcoming Justice Sonia G Gokani from the Gujarat High Court. Justice Sonia, if I'm not wrong, is a graduate in microbiology. Am I right? Yeah. So she's a technical judge and she's written a beautiful piece on human rights and IPR, which is there in the brochure. I would commend you all to read it. Thank you, Sonia Ji, for agreeing to be with us today. Justice Soman Sen. Sominda and me have gone back several years, and he's authored several IPR judgments from the Calcutta High Court. We both had the pleasure of judging a moot at the IIT Kharagpur about a few years ago, where Justice Bose was also one of the chief judges. Welcome, Sominda, to this event.
Thank you.
Next, I have the ultimate pleasure of inviting Justice Gautam Patel, GP as I call him, from the Bombay High Court. We had a fight on how I should address him, so we finally settled on GP. So he is, I'm hoping he'll have a lot of firecrackers for all of us today.
Yes.
His capabilities in intellectual property are quite well known. Authored several landmark judgments in intellectual property from the Bombay High Court. And also, it's our pleasure to share stage today, GP. It's wonderful that you're here.
Thank you so much.
Though it's a working day,